a Barclay Damon live broadcast where we discuss all things L&E, labor, and employment. I'm Ari Kwiatkowski. Let's dig in. Hi everyone, welcome to medical plan coverage during a leave of absence. Today we are going to tell you everything you need to know in the benefits space in terms of employees taking leaves, the types of leaves, and really we're going to get a good breakdown of what you should be keeping in mind as an employer or manager during that period of time. I am thrilled to welcome Art Marrapese to the podcast. Art is a partner in our Buffalo office. He has extensive experience drafting employee benefit plan documents. He regularly advises plan sponsors, insurers, and health plan service providers on issues about ERISA, COBRA, and I think he's the perfect person to kind of demystify these topics for us. So Art, welcome.
Thank you, Ari. I appreciate it.
Happy to have
Nice
you.
to be here.
So,
Yep.
I think Art, as you know better than me, with these types of issues, I think our clients, business owners, HR people get a little bit confused, understandably, and we really need you to kind of help us and break it down. So let's dig right in. Art, I think it would be helpful if you could talk a little bit about the types of leave that come up in the context of this conversation, just to kind of give our listeners a primer.
Right. Thanks, Ari. So the questions that you'll be asking, I would imagine, and the issues I'm going to address during the course of this have to differ depending on the type of leave that the employee is taking. Obviously, and I think most of our people know, our clients, that Family Medical Leave Act is a federally protected, job protected leave act. So we'll be talking about the rules that apply for FMLA leaves. Then we have in New York paid family leave, again, job protected leave under New York state law. There are health coverage issues associated with that type of leave as well. And if you have employees in other states, there may be other state law mandates similar to that you're going to need to consider, in connection with your leave policies. And then finally, the other, what I will call other company approved leave, which are not job protected leaves. They can come up in different ways. For example, the employer is not subject to the FMLA, for example, doesn't have enough employees, or the employee is not eligible for FMLA at the time, the leave begins. Maybe the leave extends beyond the protected period. This is not uncommon. Employers often do that, where federally or state mandated job protected leave ends, and they continue to administer the plan as if the employee were actively employed after the end of the mandated leave, or other company sponsors leaves as we've discussed. For example, the most common, I think, that I run into is educational leaves. So those are the types of leaves we're going to be addressing. All right.
Perfect. Thanks, Art. And could you give our listeners just a little bit more context? And I think advise why should we care about this topic? Why is this an issue for employers? Because I think when employees go out on the types of leaves you mentioned, Art, it can be confusing in terms of what to do.
Okay. Well, first of all, federal law ERISA that you mentioned at the beginning requires plan documents, summary plan descriptions, and most clients in the health and welfare space have what we call wrap documents, should be addressing this, so that employees know what their rights are. I mean, that's a big push, under federal law, make sure employees know what their rights are at any given time. But it's also critically important, and I'll indicate where this applies through the course of, our discussion. For COBRA purposes, it's really important to know which type of leave you're on. And it's important to know that because, in particular, if you're self-insured, because of stop loss considerations. And I'm not going to get into that. I think people have self-insured plans and they know what stop loss insurance is, but you want to make sure that you're not doing something contrary to COBRA in your leave of absence administration, because you could, in that case, prejudice your right to recover from the stop loss carrier if you have an employee that is, accumulating, excessive claims. So it's important for employee expectations. It's important to be uniform, to treat every employee who is similarly situated in a uniform fashion. And it's important because you need to make sure that if you're doing something that's not a default, if you will, you need to make sure your insurance carrier is on board, in particular stop loss carrier.
Great. Thanks, Art. I think that's helpful. And I'm glad you're kind of demystifying these topics for us. So, Art, let's kind of start at the beginning. Let's say that we have an employer has an employee who's taking a leave. Can you kind of just walk us through what that process looks like from the benefit side of things and what the employer needs to do and keep in mind?
All right. Well, one of the key questions there, or there are a number actually of key questions that come up when an employee, is about to go on a leave. First of all, does the employee have the right, to continue active coverage during the leave? I mean, the same coverage that the employee had before, or as the day before the leave. And the answer really very simply is yes, if the leave is job protected. So FMLA leave, New York state paid family leave, employers are required to offer coverage on the same terms and conditions to employees on those kinds of leaves as they in both situations where it's job protected. This means that the employee can't, for example, be required to pay more. Okay. It's also now, if the leave is not protected, the employer has a couple of options. All right. The employer can say that coverage is lost at that point. The employee is no longer eligible. And this is a typical default requirement for stop loss carriers. They recognize that once an employee is no longer actively employed and they're entitled to COBRA, then you need to put them on COBRA. Most employers don't do that. Okay, they don't put people on COBRA at the beginning of a leave, even if it's not job protected.
Right.
And that's the other option, obviously. You would treat the leave the same way you would treat a job protected leave and continue it for a period of time or throughout the term of the leave on the same terms and conditions as if the person was still actively employed. But if you do that, and this is what I said at the outset, you need to make sure that your insurance carriers are on board with that. Most carriers will permit it. So it's not an issue, but if you don't allow for it, if you don't communicate that, if you don't get a buy-in by the carrier, in particular, like the stop loss carrier, you don't want to be in a situation where claims are denied because you're extending COBRA in that case. So you've got the period of the leave where they're not working. If they don't return from the leave, then COBRA applies. And so your plan documents need to cover that. That's when, at the end of the leave is when, in that case, if it's not job protected, that you give the notice and that the election rights come up and that the 18-month or 36-month period begins. So you can see that you're obligating your plan to pay in a leave of absence situation, a lot longer period of time of coverage than what would otherwise be the case under law in a non-job protected leave.
Yep, I think that's really a really helpful explanation, Art, because I think, asking those kinds of questions and thinking about those issues before the employee is going to take leave right at the outset probably prevents a lot of issues down the road, as you mentioned.
Right. And the key is documentation, as I mentioned, in your SPDs to make sure whatever scenario you choose for a leave that is not job protected is specified, in your documents. Now, I guess another question that comes up, Ari, a lot, do employees have the right to drop health care coverage during the leave period? And if it's job protected, the answer is yes, but it's not necessarily the case for leaves of absence that are not job protected. Okay. So those will depend on the cafeteria plan and the circumstances of the leave. So that's really all I should need to say about that. It can get fairly involved in that situation in a non-job protected leave scenario. Because of the cafeteria plan rules. But again, the short answer is if it's a protected leave, yes, they can drop coverage. If it's not, depends on the cafeteria plan.
Got it. So, Art, can you walk us through termination of coverage generally under these situations?
Sure. I guess one way to start that discussion is, what happens during the leave if it's continued in terms of payment of premiums?
Right.
And can that result, failure to pay, can that result in a cancellation of coverage? And there are really, I think, three ways that employers handle premium payments during a leave of absence. If it's job protected, you can do prepay, so everybody pays upfront pre-tax out of some final paycheck before leave, or they pay as you go, or they catch up. Many employers do that, where the employer fronts, the employer contribution and the employee contribution during the period of leave. And so one of the question that comes up around termination most often is, what if an employee fails to pay, during the course of the leave? And the employers, in any case, whether it's protected or non-job protected leave, can cancel coverage. Okay, you always are required to pay your premium if you have a share of premium, and that's the payment method the employer is using. So it can terminate at that point. Um, Now, for job protective leaves, though, you can't terminate it unless you meet certain notice requirements. So, for example, under FMLA, typically the late date is 30 days, late. But you also have to provide a written notice that has to specify the date that the coverage terminates, and that has to be given at least 15 days before the termination date. So that's something to keep in mind under FMLA, and it's best practice, obviously, for leaves that are not protected. So I would say always advance notice of when coverage is going to terminate, and for job protected leaves, 15 days in advance of that date. Now, so I think that's what happens during the leave and how coverage can terminate at that point. What happens if an employee doesn't return from the leave? I think that's an important question regarding termination. Well, clearly at that point, if the leave is protected, then and the employee doesn't return, which an employee is considered to return if the employee returns and isn't employed for at least 30 days. But if they don't, in most cases, you'll know they're not coming back. Then active coverage for a protective leave terminates on the last day of the leave, okay, or the end of that month. All right. So for a job protected leave, that's the end date of coverage. That's when COBRA applies. So it runs from that date. So you give your notice at that point, at the end of the leave. Now, if it's not a job protected leave and the coverage was continued, okay, again, the COBRA qualifying event date would be from the end of that leave. But remember what I said before, if you're using that option, in other words, if it's not a job protected leave, but you've continued coverage anyway, then you need to get that consent of your carrier, because the 18 months is not running from the start of the leave, it's running from the end of it, and it's not job protected.
Right.
Okay, so that's a key point. And if at that point the employee owes money because you've advanced the premium, well, in that case, you can recoup it, potentially out of, PTO or other pay, subject to applicable law. Again, I'm not an employment lawyer, so I'll leave that up to the employment lawyers, just how you can do that. But it is allowed under FMLA if it's allowed, for example, under state law. How can you collect it? And that's an issue when someone doesn't return and their coverage is terminated. So let's talk about, I guess, what happens if someone does return from a leave of absence, whether it's a protected leave or a non-protected leave. If it's a return from a protected leave, it's on time. Okay, the employee has the right to be reinstated in coverage. So we talked about, the coverage being terminated,
right,
during the leave, for example, because they don't pay the premiums. That can happen. But if it's protected leave, coverage needs to be reinstated when they're reemployed with no waiting periods, basically in the same coverage they had before. And that's true, too, if the employee is elected to drop coverage at the beginning of a protected leave. Again, they can jump back in, at the end of the leave without having to wait, for example. If the leave is not protected, there's no automatic right to reinstatement if they declined coverage or if coverage is terminated during the leave. And then generally in that case, if they're on COBRA, they're on COBRA. But if the coverage continued and they don't return from the leave, then they can be, they don't necessarily have any election rights until the next open enrollment or some other change in status event.
Right. Art, thank you so much. I think that was such a great rundown of, the issues we mentioned at the beginning of the call as it relates to the types of leave. One thing I wanted to ask you about, and you and I were talking offline, and it comes up pretty often, is how these issues kind of interplay with the ADA. So can you kind of talk about a little bit about that? Because I know you get a lot of questions about that.
Yeah, we do get a fair number of questions regarding the ADA. As you know, we've talked about mandated laws that mandate and to protect jobs and that mandate health coverage. Okay,
Right.
ADA does not. Okay, even though there are requirements, obviously, that you need, accommodations that need to be made in certain situations. But the granting of health coverage, unless it's mandated by federal law, FMLA, or state law, for example, New York Paid Family Leave, then there is no requirement to offer coverage. Now, there could be issues with the Affordable Care Act,
Right.
which we didn't get into. That's a whole podcast in and of itself. Maybe even
True.
what you need to do to avoid potential penalties. But beyond that, there's nothing that mandates, coverage, ADA, for example. So that's a question, that we get, and that's my answer.
Okay. I'm glad you hit on that, Art, because I think that definitely comes up quite a bit. Well, thank you so much. I think this was a great, concise summary of some of the issues that come up and things that employers and business owners need to be aware of. But before we go, Art, do you have any last words of wisdom, we'll call it, or parting wisdom this morning?
Yeah. I think what I want to emphasize, and I have said this already throughout the course of the podcast, your rules need to be in writing. Okay, that's under federal law, under ERISA. It needs to be either separate leave policies that address benefit continuation, including not just medical, but all other types of leave benefits. And those can be incorporated into your summary plan description, or you write them directly into your summary plan description. So documentation is important. And it's also particularly important to document and to get the advance approval of your insurance carriers, in particular for self-insured employers, their stop-loss carriers, if you're doing something that grants more rights to employees than what they are eligible for under federal or state law. Okay, because stop-loss carriers, as a prime example, you're either mandated, in which case they must cover you from a stop-loss standpoint because coverage was required to be continued under certain circumstances, or if it's optional, then they need to approve the optional method that you want to use to provide coverage during a leave of absence.
Right. So documentation has to be in order, your plan documents, and you have to be very wary and keep track of the notice requirements, it sounds like.
Yeah, the notice requirements for your carriers.
Yes.
Because you don't want them to, if I had maybe a short story about this, and you can,
yes,
you can take it for whatever it's worth. But early, I'd say a few years ago, maybe probably 8 or 9 years ago, we had a situation where an employer kept a seriously disabled employer on their health plan. Okay, the employer actually turned out to be terminal. They had cancer, and they didn't keep them on the health plan through COBRA. So this was an employee who hadn't been actively employed in months, and racked up, as you can imagine, a huge amount of healthcare claims.
Right.
And when the employer submitted for reimbursement of the healthcare claims they had paid above the stop loss limits, okay, the carrier initially denied it. Why? Because the carrier said this person should have been on COBRA, not carried forward as if he or she were an active, well, he in that case was an active employee. And that was scary because it was about $500,000.
Right.
We ended up convincing the carrier to cover it anyway. And I won't get into all the technical reasons for it. It was based on an interpretation of their plan document, which was ambiguous, but which was good. So that's an example. It can happen. It's not likely to happen. I'm not trying to fearmonger.
Right.
However, that's what we do as lawyers. We help companies manage risks.
Yes.
That is one.
Yes. And I think that story illustrates the exposure that there could be if you're not taking the proper steps, because, $500,000 it's a lot that's a cost.
It was a big chunk.
Yeah.
And then, like I said, we ended up getting the employer reimbursed, for those claims
Great.
expenses, but it was scary for a period of time.
For sure. Well, thank you so much, Ari. I really appreciate you joining us today. And I know that our listeners appreciate it too, because, this topic can be a little bit, I think, intimidating, which is understandable, in my opinion, as a non-benefits lawyer. But thank you so much again. We really appreciate it.
Thank you, Ari. I appreciate it. And if any of the folks out there want, additional information or more in-depth coverage of it, they should let you know, and maybe we can do something in the form of a webcast.
Absolutely. Sounds good. To our listeners, thanks so much. We'll see you in a couple weeks. The Labor and Employment Podcast is available on barclaydamon.com, YouTube, and all your favorite podcast streaming platforms. Like, follow, share, and continue to listen. Thanks.